this means and ends issue is something which you will reflect on later. I'm not saying that I'm going to develop it right now. But what is this court doing? What this court is seeking to do
you already argued on that.
No, another aspect.
You have started on merits.
Yes, but I'm now deviating and I'm going back to a very important aspect which I want to emphasize because your lordships are saying that you will reflect on it. What I would like your lordships to reflect on is it's essentially providing an intra-court appeal without an appeal. Without an appeal, it's going from 5 to 7 without there being an appeal, without there being a process, without there being a procedure. So it's something to reflect on. I'm not saying no. I'm sorry.
And if an appeal would arise, if we were to reverse the view insofar as your client is concerned, we have...
No, even on law, you see, I was just... Anyway, I'll go on now to the stamp act, but I want your lordships to very seriously consider, because if you have in the future, some judgment comes which XYZ doesn't like, the question I ask myself is, can the Chief Justice of India constitute a larger bench and just put it before that bench without having a live list? Or decide whether there's a live list and then do it? I don't believe it can be done, but anyway, that's for your lordships to reflect on. Now, sorry. I'm sorry?
There is a there is a second matter which is listed before my...
Section 11.
Section 11 is listed before my lords, and that was placed before 5. Certainly, my lord, the Chief Justice of India in Dawoodi Bora can constitute a bench of the relevant strength. Seka Dobrik is listed before my lord. All this, my lord, may be there in the first matter. There is a second live matter which your lordships have listed.
There's no live matter, at least that I am aware of. There is some live matter there. Then that's the appropriate case. Then I completely agree with the amicus. In that case, an appropriate order can be passed.
I'm sorry, this is becoming a little excessive on this issue.
So it's a very serious issue, my lord. It's a very serious issue.
You are entitled to your view. I'm not saying this. It has been repeated.
No, because it's about the institution. And if this becomes a precedent, it's very...
On that. Said we may agree, may not agree with you, but
no, of course.
That goes on.
Yes. So now let us go to the Indian Stamp Act, which is where I want to.
Nothing on both sides have argued. Absolutely. Let's not see what I'm personally finding in all these constitution bench matters. Things go here, there, everywhere. Everybody wants to have a chance. Everybody wants to say something instead of deciding what the issue is before us. That's the problem.
And now we are clear that there is a second matter.
The writer side, because Chief is liberal enough to listen to all this, doesn't mean this goes on.
I'm so grateful.
And we have a second matter. We have a second matter which is a section 11 directly before us.
Because, my lord, we were the main...
Have you filed your written submissions? We look at the written submissions, no difficulty.
No, that's all that we are requesting.
Highlight only one point.
No, please.
This will not permitted.
You know, this will not be permitted.
Will not
I can assure you that if you argue for another 5 minutes, you'll be washing out
within half a minute.
Sir, listen to me, sir. You did that in the previous matter also in Sita Soren the other day.
Yeah, sir.
If you argue for another 5 minutes, you will be washing out the impact of the argument of the lawyers who have argued before you. So in your interest, please allow the other side to argue.
May I make a small request? Since I appeared before the Constitution Bench for NN Global, as also before the 3 judges, was led by Mr. Grohman. Would your lordships care to hear me for 5 minutes?
No. We'll see how much time we have at the end, because we have to conclude by 4 o'clock today.
Nothing more than that.
Mr. Khambata appeared for SIAC, I'm appearing for the Hyderabad Center. Look, there are certain institutional points that we want to make.
No, in institutional points, I just wanted to clarify what you will address. Are you saying that the 11.6 must address the issue of limitation first? Is that the institution's view?
No. And the point I want to make...
That's the only issue we are deciding.
That's right. No, the only
what one institution may say, another institution may say is not relevant to mine.
The only point I want to make, in fact, Mr. Khambata sort of hinted on it. And my respectful submission is that your lordship should, in fact, be looking at effectively parity, take the view that under section 11, your lordships can't take evidence. If your lordships takes that view, then my lords, the entire section 33 of the Stamp Act becomes inapplicable. And that's really what I want to make good. That's one point.
So you are really on this side, Mr. Diwan.
Lords, on the point of 11, in fact, Mr. Khambata pointed out. But on the
your physical situation, you know, situationing.
Separability.
He's undercover.
The reason why I am here is because on the doctrine of separability,
My respectful submission is going to be that no, they're not separable documents for the purposes of the Stamp Act. And to that extent, the 5 judges are correct because you can't expand the doctrine of separability beyond section 16. And that's the other point which I've made. Good. I don't need more than 2 minutes. 10 minutes on these. That's it. Because Mr. Khambata has addressed your lordship suggesting what Mr. Khambata has suggested is that expand the doctrine of separability. My respectful submission is.
We are not going to that issue.
I just know, but that's the basis. No,
We don't understand. It will narrow down.
Correct. But why are you
After narrowing of issues, still everybody wants to address on everything on this earth which is possible to be said under the earth.
There is the entire genesis of NN Global 1 was the doctrine of separability, suggesting that because of the doctrine of separability, the document didn't have to be stamped. NN Global 2 goes and says, no, it is not separable. They are all part of the same agreement. The argument made by the other side is expand the doctrine of separability. That is going to be inconsistent with our act. It's going to be inconsistent with the entire line of English law decisions which we've continued to follow, which have clearly said that it is separable only for the perspective of invalidity, not from the perspective of every other matter. It is still a part of the bundle.
But it's not necessary for us to see what are the outer limits of the doctrine of separability here at all. We have to only decide as to whether at the stage of section 11(6)(a), the court is required to examine whether the instrument has been insufficiently stamped.
And on that point, my respectful submission is the way out of this conundrum is by taking the view that your lordships cannot receive evidence under section 11(6), because your lordships is not a court under 2(1)(e). If you're not a court under 2(1)(e), because the appointment goes either.
All right, yes, Mr. Diwan.
That's the limit submission that I will make.
So, Manoj, very quickly, may I just take you, please, directly to page 329 of volume 4A. So now I'm on the Stamp Act. So I'll just make a few comments and a few provisions. So first, your lordships may go to page 329 of volume 4A, where you will find the definition in 212 of executed and execution. Executed and execution used with reference to instruments mean signed and signature and includes attribution of electronic records within the meaning of section 11 of the Information Technology Act. Then just please read a little further, 214. Instrument includes every document by which any right or liability is or purports to be created, transferred, limited, extended, extinguished, or recorded. B, a document, electronic or otherwise, created for a transaction in a stock exchange or depository by which any right or liability is or purports to be created, transferred, limited, extended, extinguished, or recorded. So, Manoj, I want to now just tie up these two definitions with the definition under Section 7 of the Arbitration Act. Arbitration Act is required to be in writing, where I think that's common ground. Please link that to the definition of the word instrument. I believe there is no escape from the fact that the arbitration agreement is an instrument broadly covered by this definition. Now, please move on. Section 3, your lordship knows, is the charging section, so I'm not taking you to that. Please go directly to Section 17. Section 17, which you will find at page 348, same volume, 348. Now, this is the point which we alluded to in the morning. Instruments executed in India. All instruments chargeable with duty and executed by any person in India shall be stamped before or at the time of execution. Now, this is the clear mandate of the law. So, Manoj, I recall Mr. Datar was mentioning that he had his client in the old Madras City Civil Court days who used to only stamp 50% of the documents. All right, you run the risk, but the law mandates that you must execute at the time or before. Before or at the time of execution, you ought to pay the stamp duty. So this is something which the court will keep in mind. That's the time when you do it, but that's not all. So Section 18 is for instruments other than bills, notes executed out of India. So, Manoj, with your permission, I'm going to skip that. Please now go to Section 31. This is important for my purposes. You will find it at page 355. Now, this is the route which we suggest to the court. This is the correct way out. What happens when a Section 11 application is filed and there is some dispute with regard to it? It's so I'm suggesting, I'll read Section 11(1) and then I'll just make this short submission. Adjudication as to proper stamp. When any instrument, whether executed or not, and whether previously stamped or not, is brought to a collector, and the person bringing it applies to have the option, to have the opinion of the officer as to the duty, if any, which may be chargeable, and pays a fee, such amount not exceeding ₹5 or not less than so and so, as the collector may in each case direct, the collector shall determine the duty, if any, with which the judgment, the instrument is chargeable, with which in his judgment the instrument is chargeable. So this is in short the route we are suggesting. First, at the on or before execution. If not on or before execution, shortly before you make a Section 11 application, just as you get your pleading drafted or before you issue a Section 11 notice. I'm sorry.
You are right. This is a provision.
Yeah, this is a provision, and
1 minute,
this
please.
is the correct way. Yeah, I'm sorry.
Practical terms, if we apply it, it will be chaotic. It will be chaotic, to say the least.
No, why would it be chaotic?
Because
that's what the law requires.
because
I'm
you
sorry.
don't know what happens if you apply over there, how much time it takes.
No, so to that therefore I'm making another
And
suggestion.
the
I'm
type
sorry.
of orders which are passed.
No,
Again,
so I'm just making a suggestion to the
less
court.
said the better.
This is, no, possibly your lordship's experience
And
is
it's
wide.
not mandatory in law. It's not mandatory in
No,
law
I'm
that
not.
we have to
I'm-
go
I'm-
under 31.
No, so Manoj, may I just say this? As far as this.
Don't make it mandatory by a judgment of this court.
No, I'm saying that first, what is mandatory is at the time of execution or before execution. That's the mandate
the
of
stamp duty
one.
part. That's
Stamp
stamp
duty part. Second, it's not as if a party is hobbled and has to wait. He or she can, before issuing the notice under Section 11, arbitration notice, or before making an application, he can follow this route. I'm not putting it any higher than that. And your lordships, while molding the relief or issuing directions, may issue appropriate directions that in a case where the matter is pending adjudication, Section 11 can proceed. That's all. Now I go to the next point. Now look at 33. Look at 33. Please look at 33, which your lordship will find at 357. Now, examination and impounding of instruments. Every person having by law or consent of parties authority to receive evidence, and every person in charge of public office, except an officer of police before whom an instrument chargeable in his opinion with duty is produced or comes in the performance of his functions, shall, if it appears to him that such instrument is not duly stamped, impound the same. For that purpose, every person shall examine every instrument so chargeable and so produced or coming before him in order to ascertain whether it is stamped with a stamp of the value of the description required by the law in force in India when such instrument was executed or first executed. So here I make just 2 points. Your lordship said that we can look at marginal notes, at least to judge the drift, etc. of the section. This uses the expression examination, and then the second is impounding. I believe that I have no doubt, following your lordship's judgments, that when a Section 11 court is applying its mind, your lordships have held it's not mechanical. There is a application of judicial mind, and therefore the expression is examination, and this would cover a situation where a court is looking at it under Section 11. This is one aspect. Now, please go. Your lordships will just move on to Section 35. Section 35, which is on page 359. Now, please see this. Here we have there's a slight difference, at least on construction. We see this as 4 distinct points, but Mr. Kambata mentioned that there are 2 buckets. Please see, instrument not duly stamped, inadmissible in evidence, etc. No instrument chargeable with duty shall be admitted in evidence for any purpose by which a person having by law or consent of parties authority to receive evidence, or shall be acted upon, registered, or authenticated by such person or by any public officer unless an instrument is duly stamped. So there are 4. 1, as your lordships correctly said, receiving evidence, admitting in evidence. That's 1. 2nd, acted upon. 3rd, registered. And 4th, authenticated. So there are 4 distinct situations which Section 35 envisages. Admitting in evidence is one of them. Section 11, I would respectfully submit, is not an admission of evidence stage. It's a stage of acting upon. I don't think there can be any, that's our submission. I don't believe there's any doubt, at least in our mind, with regard to the fact that the Section 11 court is required to act upon. Now, if this is the mandate of the law in terms of Section 35, I've already read the embargoes, etc., with regard to the section. Then the scheme of the statute, at least to us, appears to be that before a court under Section 11, if this issue is raised under Section 11, however narrow the jurisdiction, because undoubtedly it's a narrow jurisdiction, this would be within the duty and obligation of the court. Now, recent judgment is It's restricted to the eye of the needle. A fourth expression your lordships have used in Vidya Drolya and other judgments is to cut the dead wood. The fifth is, it's a very narrow jurisdiction on existence and validity, which is the magic eye judgment. And of course, when in doubt, refer. So having regard to the conspectus of these tests, which are really different ways of saying that it's a narrow jurisdiction, nevertheless, according to us, just on a reading of the Stamp Act, and I have made my submissions on Section 5 of the Arbitration Act, there doesn't appear to be any reason or justification to exclude the operation of the Stamp Act at the Section 11 stage. Now, my lords, we are fortified in this, and here I'm just requesting you to please, I'll just request you to turn to, if you would, to Volume 2, page 6, please. So Volume 2 is my submissions. Volume 2, page 6. Please just go to page 6. It'll just save me a lot of time. Would your lordships have para 1.4? Sorry, Manoj, I'm on page 6. Do you have para 1.4 page? No, I just want to spend, I'll just address the court. Which page? Same thing? Para?
Line of what interplay the
To Section 35 will apply because of the and shall or shall be acted upon.
Yes, acted upon. So there are two.
Acted upon is also qualified by.
Yes, yes. I'll
by
just
any
go there.
such person. Now, any such person means who?
No,
A
that's the
person
registry, correct?
having by law consent of parties authority to receive evidence.
Yes, but yes,
Acted
yes.
upon is also qualified by any such person. Any
Right.
such person means the person referred to earlier.
Right.
Of
No,
course, there is a
can
word
I-
public
can I-
officer. I mean, I don't know whether
No,
you
but
can
we are a
put the
court,
court as
Manoj.
a public officer. Possibly the court is a public officer.
So, Manoj,
Sorry?
no, so this is, I mean, astonishing.
But a Section 11 court may possibly be a public officer. Perhaps.
Here, I may just draw attention to 33(2)(b). There's an act of delegation which the Stamp Act itself envisages. The High Court can delegate this function of examining and impounding to an officer. which includes an arbitrator, he's authorized to take evidence.
Lords, in fact, my submissions deal with this very point, saying that all of this goes to the arbitrator if you read 33, 35, because what parties have done is that by consent, Lords, even in terms of the Arbitration Act, by consent, parties have agreed that as far as their disputes are concerned, it is the arbitrator who takes in evidence. That happens because of Section 19 of the Arbitration Act. So when you harmonize both the provisions.
The 33(2)B recognizes this.
May I just make my, sorry. So I'll just, sorry, I'll just summarize it, how we understand it. We believe, if we are correct, that if it's going to an institution of any sort, this embargo under Section 35 won't apply under the scheme under which it presently applies. That's our understanding.
Yes.
That's one. Equally, we have no doubt that if it is the High Court or the Supreme Court, then it would be covered and under Section 35, and it would be covered not in the sense of taking evidence, because your lordship may not be at that time admitting it to evidence, but certainly it is to be acted upon. That's why we sought to link acted upon with your other judicial responsibility, judicial application of mind to satisfy yourself on existence, however confined that jurisdiction may be. That's the short and submission. So we believe 35 does apply to a Section 11 court, and it does apply to I mean, whatever, to the High Court or the Supreme Court, as the case may be. That's where we are, and the language is wide enough. Otherwise, it might be rendering this ocious. So that's it. So, Manoj, I was now on, if your lordship recalls, volume 2, page 6, please. Page 6. May I state the point?
Yes.
Yes. So we are on para 1.4. I'm drawing attention to 1.4 because of the constraint of time. What I want to just mention is that, look, we've had not just one stray judgment. In fact, to one judgment, Justice Gavai and Justice Suryakant are a party. That's the present judgment. We've had a series of judgments which we have encapsulated in paragraph 14. There's a total of about 12 of our judges who've looked at this over the years from 2011 onwards. And the narrowest SMS was, which is the 2011. That Justice, I think, Ravindran and Justice Patak, they looked at it from the Stamp Act point of view. And they said that, look, this is clear to us, and therefore having regard to that, and they placed it on that. Thereafter, just have a look now, I'll read 1.4. It is submitted that this Honorable Court in SMST, so that's the first one. Then we've got Naina Thakkar versus Annapurna Builders. Well, that's also two learned judges. Black Pearl Hotels versus Planet M Retail Limited. That is three learned judges. That, your lordship has that? 1.4. I'm on para 1.4. Page 6, your lordships have it. So I'm just, to save time, just reading this. So we have SMST, that's the leading judgment, I mean, in point of time. Then we have Naina Thakkar versus Annapurna, which your lordship may note is two learned judges. Then we have Black Pearl Hotels versus Planet M Retail. That, I believe, is three learned judges. Then the judgment referred to Garware Wall, Justice Nariman and Justice Vineet Saran's judgment. Garware Wall is mentioned. And the present impugned judgment, which was also by three learned judges. So it's what the suggestion which we are making is that what has come about in the five-judge bench. I mean, I'm not saying that there was a reference to the five-judge bench judgment. There is a concern there. But when you have a long line of judgments spanning more than a decade in a situation such as this, on an issue such as this, I believe it is an eminently possible interpretation. The question before the court also is as to whether, because when there is in a commercial field a long-standing set of precedents and understanding of our court, we don't believe it ought to be lightly upset. Not that I'm suggesting that your lordship is not, going to consider this very fully, but I'm just suggesting to the court that please do not upset this, because we've given you a way out. The way out is not to give a premium on dishonesty of some person who decides for 50%, I am going to pay stamp duty for only half my cases and I'll take a chance. That's hardly the situation. The law requires you to pay stamp duty, pay it. If you don't pay it, the law gives you another chance before you approach Section 11. And if not, now I come to the if not, what is to happen? Now here, just please go to page 36, same written submissions, please. 36, please. Now here, now just have a look at two judgments referred to here, and Mr. Nair will expand on this. Your lordships have para 4.5. 4.5 your lordships have. So I'll just sum it up. So after our 5-judge bench judgment in NN Global, both the Delhi High Court as well as the Bombay High Court had occasion to examine how are we going to do this. So there are 2 judgments, Splendor land base, and there is a further one called, I think it's John Cockerill. Yes, that's mentioned in 4.6, correct? And they have given a streamlined process. So I am commending that with whatever further suggestions which your lordships may feel appropriate for the purposes of how to move forward sustaining NN Global. So this is another point which I thought we'll make. This wraps up the correct scheme. Now I want to make one further final set of submissions with regard to the Contract Act. Now I want to, may I just make that submission very quickly? Now please just take up the Contract Act. Yes, and your lordship will find that at page 280 of volume 4A. Volume 4A.
Which provision are you referring to, Mr.?
Sorry?
Which provision are you referring to, Mr. Devan?
No, much was made of those definition clauses, etc. Now, I just want to point out what is the Contract Act saying, and the whole thing is void, etc. That's not the case at all. And since we're straying, I'm meeting this because much time was spent on these particular definitions and on how the Constitution bench has done it and how Justice Nariman in Garware dealt with it. So I want to just explain it. The standard, the original template which was used by our court was founded on SMS Steel, which your lordship sees Stamp Act. Thereafter, the bench felt in Garware that there may be another perspective. Now, what is that perspective? Let me just place it. So your lordship has now page 280. So just now see the interpretation clause section 2, please. On that page. In this act, so first of all, it's in an interpretation clause. Then it says, in this act, the following words and expressions are used in the following senses unless a contrary intention appears from the context. Now, please go on to what was emphasized, G, 2G. Now, let's see what this, first let's read it, and then the context, and then see whether it has any reason to deviate from the 5-judge bench. G. An agreement non-enforceable by law is said to be void. Is said to be void. It's not it is void. It is said to be void for the purposes of this act. Now see the next one. An agreement enforceable by law is a contract. And then please see J. A contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. So, the ambit of the expression in section 2 of the Contract Act is enforceability, and relative to enforceability, whether an agreement is void or not. That is how this is to be understood. It's not to be understood, oh, the whole agreement is void, nothing can be done. That's absolutely a wrong way of looking at it. What the court is saying in Garware, etc., is that once you remove this taint, or you remove the shadow, as your lordship said, or the cloud, as your lordship said, then it becomes fully enforceable. So for all intents and purposes, your contract, upon being appropriately stamped, becomes enforceable. There is no peril to commerce, as is being suggested, that the whole entire, the country and commerce is going to come to a grinding halt if this judgment is allowed to sustain. A line of judgments which has held the field since 2011. So my respectful submission is, there is no justification on, and when your lordship recalls, for example, commonly, what do we understand? That if there is a fraud, for example, everything is void because fraud vitiates everything. But that's not how the Contract Act looks at it. The Contract Act says that if there is a fraud, it is voidable at the interest of the counterparty who was induced. So for the purposes of the Contract Act, what is void, what is voidable is much more nuanced than what is being suggested by the other side, and it ought to be understood in this restricted context. I'm very grateful. Thank you.
Thank you, Mr. Devan. Yes, Ms. Nair.
Very briefly, my lord, because most of it has been covered. What's the aspect that really, my lords, what we have heard my learned friends argue, my lords, nobody has, to my mind, contested the fact that section 35 has to be given play. that is not in dispute. I don't think anybody has contended that Section 35 has no role whatsoever in an arbitration or in a contract. The only question is, at what stage will it trigger? Will it trigger at an 11th stage? Or do we, my lords, if I can call it that, if I can call their argument the kick the can argument, my lord, that should be send it down to the arbitrator and then that the arbitrator or the arbitral tribunal deal with it. Now, my lord, the 11.6a point, my lords, as primarily Mr. Datar contended, my lords, was based on three facets. Because 6a, my lords, can be construed two ways. One is either what is the width of the jurisdiction that is intrinsic in 6a, or an efficacy argument, that it is not efficacious at this stage, we are delaying arbitration, that is not in the interest of ADR, etc. So let us send it down back to the arbitrator because anyway 16 has some kind of mechanism. I'll focus first, my lords, on the 6a part. Three aspects, my lords, that were highlighted in 6a. One, my lords, was the use of the word confine. It says confined to the existence of. The second part was existence, and some, my lords, emphasis was laid, my lords, on the non-obstante clause, saying, my lords, that because of that non-obstante clause, we should now, my lords, construe it to mean that other statutes or, my lords, earlier judgments have now kind of been diluted. Lords, for each one, my lords, I just give few references, my lords. As far as the width of 6a is concerned, post 6a, in fact, most interestingly, in our case, I don't want to get into the merits of that curative, etc. Actually, 6a does not arise. Mine is an 11.6 case because the notice came earlier, etc., etc.
Before the other bench.
Yes. But in 6a, my lord, your lordships have consistently held that existence means validity as well. Consistently. I'll just give those references, my lord. I don't want to read them. Garware, my lord, which is at page 33 of volume 5a, para 29. In Drolia, my lords, which is page 73, volume 5a, para 153 and 154.4. And my lords, NTPC versus SPML, that is page 1806 in volume 5a, at para 25, my lord, where, my lords, this eye of the needle test has been propounded, and, my lords, specifically held that the primary inquiry is about existence and validity. So, my lords, as far as that aspect of 6a is concerned, my submission is that validity is a, my lords, legitimate exercise under 6a, because Mr. Banerjee suggested, my lords, reading various authorities and the uncitral, my lord, model, that perhaps it has to be a very restricted and narrow, my lords, approach to 6a, virtually, my lords, taking us back to pre-SBP and Konkan, etc. But, my lords, that has not been, my lords, to our understanding, the interpretation given by your lordships, my lords, even after 6a. Existence includes, my lords, validity. Secondly, my lords, as far as the notwithstanding argument is concerned, lords, the most detailed, my lords, in fact, there's a reference in Duro Pelguero, my lord, that the amendment in 2015, because the 6a comes in 2015, that it was intended only to overcome SBP and Bogara polyfabs. SMS was known to the legislature at that point. If the intention had been, my lord, to whittle down the scope of 6a and take out this dispute of stamp, my lord, there would have been appropriate language used. And, my lords, in Garware, my lord, because that contains the most detailed, my lord, discussion as to the legislative history of 6a, including referring to the Law Commission report, etc. Lordship may just note, my lords, paras 12 to 14, 19 and 22. And it is clear, my lord, that the legislative history was such that it only intended to take care, my lords, perhaps the legislature felt that as a result of SBP and Bogara polyfabs, that too many issues were being gone into at the stage of 11 to restrict the scope. But, my lords, in my submission, my lord, that restricted scope does not take away, my lord, the fact that you can get into validity and therefore consequently this issue of stamping, which I separately deal with. But there's one thing I want to show, my lords, why the word examine, my lords, will or could, my lord, encompass the examination on the question of stamp. Kindly just have SMS, one paragraph in SMS, my lord. That is in volume 5A, page 8, at para 22.1.
Para?
22.1. The conclusion starts at 22. I just want to read 22.1. I'm sorry, it's page 16 of the running page, my lord.
Talking about volume 5A.
Yes, volume 5A, my lord. It's the second tab.
Page 16, not page 8.
At page 16, para 22.1. Starting at 22, my lord. May I read?
Yes.
We may therefore sum up the procedure to be adopted where the arbitration clause is contained in an agreement which is not registered, but compulsorily registerable and which is not duly stamped. The court could, before admitting any document into evidence or acting upon such document, examine, please note the word, my lords, examine whether the instrument document is duly stamped and whether it is an instrument which is compulsorily registerable. Now, my lords, the word examine, your lordship will find in 33(2) of the Stamp Act. That is the extent of the duty, my lord.
Thirty-three point?
33 subclause 2. The word used there is examine. But after the impounding, I'm sorry.
One also says the court should, before admitting in a document in evidence.
Or acting upon.
Yes.
Yes,
Put it together.
correct, my lord.
So here there's one difficulty, we accept this proposition.
Yes.
If we accept that the arbitration agreement is severable, now even if the parent contract or the underlying contract is held to be bad, is to be impounded, section 65 and 70, both restitution as quantum merit will apply.
Yes.
Cannot then it be argued that this issue can be gone into by the arbitrator as by a civil court?
Lord, the question, the severability, Lord, Mr. Diwan has a more elaborate argument on that. But
so quantum merits are decided by the
yes,
arbitrator.
they can certainly decide, but the question, Lord, the question is this. Lord, the question is this: the argument of severability, does it extend beyond the purpose in 16(1)(b)? Yes. Because our submission is not the purpose of the argument of severability is limited to that. It does not preclude, my lord. Yes. No, why not? Of course they can, my lord. But the question is the court precluded under 11? Yes. No, not 35. Kindly see what is the language of 35. 35 first is mandatory. It says shall. There is no option there, really speaking. It shall and shall not act upon. Both. I'm sorry, my lord. No, but since your lordship mentioned about, the point I was trying to make is, I'm sorry. No, my lordship, sir. Now, Lord, 33, the point I was trying to make, my lord, the word used in SMS was examine. They were conscious, my lords, while making the amendment. The word used in 22.1, para 22.1 is examined. The language in the Stamp Act is examined. The language in 6A is examined. It is not, my lords, that there is any greater degree of inquiry that is required. So examine, my lords, will encompass. An examination is to whether a document or an agreement is properly stamped or not. Sorry.
else?
Not two, just two, three short points, my lord. Lord, the second aspect on section 5, my lord. Section 5, my lords, is not a bar. Because section 5 only says, my lords, notwithstanding under as per this part.
That Mr. Diwan made a point. He said
Yes.
the object of 5 was to prevent suits being filed.
Correct, my lord.
To delay arbitrarily.
But once there is a
Taken note of.
once there is a jurisdiction under 11 or 9 or my lords 34 or 37, the width of that jurisdiction is not controlled by 5. Just one judgment, my lords. Your lordships may note it. I'll not, my lords. I don't have the time to read it, my lord. That's Chingtel's, my lord. It's in volume 5B, my lord. At page 547, sorry, 522. At, my lords, paras 38 and 39. At 547. that 5 my lords will not control the actual width of the jurisdiction. Please.
I'm sure a lot of other states have this. Under the revenue law, in Maharashtra, if a certain point arose before a civil court, you had to refer it to the revenue authorities for determination. What used to happen then is the moment you got the revenue authorities, everything then went into a series of procedural remedies, a revision, a statement of case, an appeal. So what the experience was that the entire process before the civil courts was stalled because until a finding was reached by a revenue authority, and exactly that's what's going to happen here. The moment we read the stamp act provision to the 11.6a stage, the net or the 11.6 stage, the net consequence is going to be that the entire gamut of remedies under the stamp act will have to be exhausted. And that never comes to an end. It goes on for years.
There I have two submissions, my lord. One is, my lord, there is assumption implicit in this that the arbitral tribunal will handle it better. And that the arbitral tribunal will be able to control the stamp proceedings equally well. That's an assumption, I would say, with respect, my lord, because if the court is not able to control it, my lord, as your lordships are observing, lord,
I don't support control it. It's not.
No, it's not controlling. That I'll deal with separately, my lord.
Less controls it more. To the intent of an arbitration act, very basic summary nature of proceeding 11.6. Why
Yes.
should we detain at the threshold?
And actually,
Whether they control it better, not control it better, the arbitrator to
No,
say.
but if the concern is
the 2019 amendment, though not enforced,
yes,
gives us an idea about the mind of the legislature,
correct, my lord.
which is to continuously constrict or confine the intervention of the court at the
Yes.
first look stage
Yes.
by taking it away completely if the amendment were to be enforced.
Yes, my lords. Therefore, my lords, what we had suggested, my lords, kindly just have that the order of the judgment of the Delhi High Court in splendor, because my lord, it sets out a whole scheme as
That
to
you have made a point. We have made a
as to my lords how to control this.
Delhi and Bombay.
Faced with this constitution-made judgment,
They have to implement it.
whether everything should be left in a limbo or they devised a method which you are right.
Actually, my lord, it's not a case of limbo because they've actually devised a method to expedite it and control time frames. In fact, in the Bombay case, they found that the difference was 44 rupees.
But they were implementing the constitution bench.
Given the
It is it's a workable solution is what I'm saying. What I'm suggesting, my lord, it's a workable solution. It's not a solution that can't work, my lord.
Thank you, Mr. Nair. Thank you very much.
Only one, sorry, I'm sorry, one last point was on this, on the question of, my lord, of 35, it says for any purpose. In Avinash Kumar Chauhan, your lordships have said, my lord, if it is not stamped, unlike 49 of the Registration Act, it cannot be used even for a collateral purpose. That is, my lord, Avinash Kumar Chauhan is in volume 5B, page 104, at paras 22 to 25, page 110. I'm grateful.
Because I propose to take no more than 10 minutes. So that my learned friends will also.
What are your submissions, Mr. Diwan?
Was my
Are you now mentally on that side or are you still on this side?
So, Milord, I have always, because I'm appearing for an institution, Milord, my difficulty, Milord, was as far as this, the challenge to the NN Global judgment, Milord, was this. We affirm NN Global, the 5 judges, on the basis that the doctrine of separability is limited and that the arbitration clause, save and except for matters under section 16, is part and parcel of the main contract. So to that extent, Milord, we affirm NN Global too. The little leg, Milord, which stands on that side, which is in fact the practical leg, is that under section 11, an arbitration need not be stalled if an arbitration agreement is inadequately or not stamped at all, or the main contract is not stamped.
The only point we are deciding.
Now, why is the doctrine of separability relevant?
That is the only point we are deciding.
So that's correct. In fact, your lordships heard Mr. Khambata at length on the doctrine of separability, where he suggested.
I've been saying repeatedly, and I think on behalf of people have gone here, there, in many places.
That's right.
We have repeatedly, I think, at cost of repetition, the Chief Justice, all of us have been repeating what we are deciding. If we've repeated what we are deciding, what's the point of saying, he said this, so I'm saying this, or so-and-so said this, so I'm saying this?
Why is the doctrine of separability relevant? I won't take more than a minute to explain to my lords. If your lordships holds that today the parent agreement and the arbitration agreement are fused for all purposes save and except for section 16, then the challenge as far as inadequacy of stamping really goes to the challenge as far as the main agreement is concerned. And where there could be, where the level of stamping, the quantum of stamping becomes a matter of dispute. It's a matter which...
They're not really submitting before us.
Because I'll only tell your lordship...
The point is, if you are debating it, I agree, you have a right to say.
Right.
But we are not dealing with it. We have said so 20 times we are not dealing. We are saying the only issue we are dealing with is, should at the stage, and Mr. Devan addressed it, he felt that no, at 11th stage itself, in the first blush, we should look into it.
Right.
Now there says, no, don't look into it. That's all.
Well, I have no difficulty. My written submissions are there. In case your lordships go into the doctrine of separability, my lords, my submissions are there that it must be restricted. That's Well, now comes the second point, and the only point that I will then address my notes on, which is in relation to section 11. Section 11, and whether, my lords, there should, in fact, should an arbitration be stalled. My lords, if your lordships has section 33
are you
of the Stamp Act.
On the, I thought you were on the side of the, this
on
side.
on their side, I just have a...
Then there's nothing to add?
No, the only difference, my lords, is this. Mr. Datta seemed to suggest that a section 11 court could perhaps take evidence. He said, I'm not arguing that they can't take evidence. Mr. Khambata said, perhaps they cannot take evidence. My position...
They're not going to why do we have to go into these?
Because of section 33 of the Stamp Act. And I'll tell your lordships why. If your lordships has section 33 of the Stamp Act, what does 33 set out? Because what 33 sets out is that every person having by law or consent of parties, authority to receive evidence. So that's the starting point. Now, by my respectful submission is this. Once parties have chosen arbitration as a mechanism for resolving disputes, they have by consent under the Arbitration Act authorized the arbitral tribunal to be the body which receives evidence, and that becomes evident from section 19.
Thank you. That's exactly what I said before. You have a chosen judge. You have an arbitrator, the arbitrator will take a call.
And the consent. So therefore, my lords, as far as the second part of section 33 is concerned, it doesn't arise because by consent, you've said the tribunal receives evidence. Now, my lords, what about the first part? Every person having by law authority to receive evidence. Now, that is where, my lords, your lordships has to consider the Arbitration Act and section 11. There, my respectful submission, my lords, is this. Under section 11, your lordships is only appointing an arbitrator. Your lordships is not the court under 2(1)(e). That's the first point. So the purpose to what followed from the Honorable the Chief Justice, which is that all you're doing is examining the existence of an arbitration agreement. My respectful submission is that that power is constrained only to examination of the existence. Now, when a party comes to a court under section 11 and says, please don't act on the agreement because it is not inadequately stamped, that's not a dispute which goes to existence. Because the agreement exists. The party accepts that it signed the agreement in writing in terms of section 7. Because all that section 7 requires is an agreement in writing which is signed by the parties or perhaps exchanged in other forms. Now, if the agreement exists but cannot be enforced, then under section 11, the court has no power to go ahead and impound a document or even look into the Stamp Act. And therefore, in my respectful submission, really the way out, and that's really the end of my submission is this. The way out for the court is to say, we are constrained because we are not a court under 2(1)(e). The section 11 court has no power to receive evidence. If it doesn't receive evidence, it looks to see whether there's an arbitration agreement in existence. If it is, it refers the matter to arbitration. Because the defense is not that there is an inexistent agreement. The defense is not that I've not signed the agreement.
You are therefore supporting that submission.
To that extent, Manoj, I support that position. Manoj, that's the long and short of
Thank
what I
you,
have.
Mr. Diya.
Manoj, all of this has been set out in my written submissions, Manoj. I don't need
Thank
to
you, Mr.
address
Diya.
it.
I'm on 707.1.
No, 1 second. Mr. Khambata, how do you read that one part of section 35? Just a couple of questions really, which, one, what is the object of section 5? I'll come to that in a moment. Section 35 says of the Stamp Act, no instrument chargeable with duty shall be admitted in evidence for any purpose by any person having by law or consent of parties authority to receive evidence, right?
Yes.
A court under 11 is not that authority. You don't, that's fair enough. Now, or shall be acted upon, registered, or authenticated by any such person. Now, any such person means the person referred to earlier.
The first part.
Who is authorized to receive evidence. But now, what follows is, or by any public officer. Now, would a court technically under 11 not be a public officer? Because now see 33 for a moment.
Yes.
33 has slightly different language. Person in charge of a
Of public office.
But I would, with respect, may not say a section 11 court is a public officer. It's a court under section 11 for the purpose of section 11, not a public officer. Public officer is an officer who is of the executive, discharge administrative functions, etc.
Yeah.
Therefore, section 11 court may not be covered by 33 or 35.
33 and 35 were dealt with by Justice Roy, and this expression acted upon was dealt with by him in about 7 or 8 paragraphs.
What did Justice Roy hold on acted upon?
Well, Lord, what he says is, your Lordships will see 35 is a consequence of 33. 35 is not a standalone.
Absolutely.
33, my Lord, the 33 has 2 parts. 33(1), the operative part is, my Lord, I'm not going to the first part, my learned friend has addressed your Lordship on that. Shall, if it appears to him that such instrument is not duly stamped. So that is an examination which is wider than the 11(6)(a) examination. So, my Lord, the 11(6)(a) court is constricted in its examination as compared to any, assuming, my Lord, it's a public officer, it's a case of concentric circles, my Lord.
So your submission really is that the scope of the inquiry in 11(6) court is much more limited.
And that
Or
is why
11(6)(a)
your
court.
Lordship sees Justice Joseph's judgment, which is summarized in paragraphs 161 to 169. His 2 reasons are, he has to then go to the extent of saying that it does not exist in law. That's the error in the judgment. He did not need to, if that leap was required, to bring it within 11(6)(a). So, my Lord, if 33(1) doesn't apply, 33(2) doesn't apply, then, my Lord, 35 doesn't apply. Justice Roy has taken a slightly different approach as well, that 36 has to be read. And, my Lord, there is a case on limitation where there is a decree. A decree is enforceable even though unstamped. So on that basis, he says a decree is, well, not the word acted upon is not an absolute bar. It's a curable defect. That is how he has got around it. I can mention paragraph.
We'll have a look at it.
Look, there is one decision.
So there are various ways of, my Lord, getting around 33 and 35. We can put in a note on.
Because there's one decision of your Lord, which in fact defines public, which deals with the word public officer in the context of section 33 read with section 73 of the Stamp Act.
What is the citation?
No, the citation is 2005, 1 SCC 496. It's not on record, but we've just taken this out now. And that, Manoj, at paragraph 3, looks at a public officer as one who would be somebody under section 73 of the Stamp Act, which says every public officer having in his custody any registers, books, records, papers, documents of proceedings, etc., the inspection of which. So, Manoj, there were a category of public, there's a public officers having in their custody registers, etc., were, Manoj, used by your lordships in this decision to say The term public officer having in his custody as occurring in section 73 can be defined by having regard to the expression public officer.
To 73.
It appears to be, as it says, the term public officer as occurring in 73 can be defined by having regard to the expression public office as occurring in section 33. And then it says the central legislation, including 73, took care to see how the power to inspect was confined only to documents, etc., etc. That appears, Willows, to be one possible.
For a section
All
11
request-
Thank you very much.
May I just one point, at least our position. We believe that the High Court and the Supreme Court is covered by the opening part. Every person having by law or consent of parties authority to receive evidence.
Just one.
We are covered by that. We don't need to really go any
Just
further.
one request. Mr. Datar is not here. There's a note we had made. We wanted to just hand it over. This covers our points in rejoinder on 5 minutes. This I'm handing over the note.
My lord, we just.
Your Lordship may see.
Section on the interpretation of Hindustan Steel, which is in para 65 and 70 of the Constitution bench judgment. Because what happened there was, after my lord Stanley was made, then it was that it should not be acted upon. So my lord, that is also analyzed. So therefore, to say that the Hindustan judgment, Hindustan Steel judgment will actually have an impact, my lord, is not correct. Because what actually can be acted upon can only be enforceable.
Thank
Sir,
you.
may I put in a short note on public officer, just a short one?
In another 2 days.
Yeah, we'll- grateful to it.
As an incorporation of the international law perspective,
We'll have a look at it. Thank you.
that's under Article